Yes.
A sincere prayer for an accommodation. of
All
victim
prayers are
family.
sincere.
No, my lord, the situations is, there are two situations.
Yes.
One, that person in 2014, he was 70 years old. And his whereabouts is not known to me. Somebody else has engaged me and just I have informed him. And he is also unable to trace him. He is not living in Guwahati now. One.
You
Two,
argue as an amicus. We'll hear you.
and I appreciate why. Today, my lord, I have some personal difficulties. I have to go out of station now. My lord, on that count even, my lord, if I lost it.
2014,
I
Mr. Sharma,
appreciate-
very
I can
difficult.
understand this. This
Very
it's
difficult.
painful to me too, my lord, because it's a burden in my chamber all the way.
You assist as amicus.
My lord, of course,
Evidences are there.
I'm not saying that I will
If
not
he's
argue.
dead, no. If we appeal, very good.
Right,
If
right,
it's
my lord,
not,
but
if we don't, if we set aside,
I have
if
said,
he's not here, let him be happy somewhere else.
yes, yes. On the second ground, my lord, that some personal inconvenience.
After vacation.
I'm
On
obliged.
a date to be fixed.
Lordship,
Very- Yes, Sharma.
item number 16, I
Yes.
have instruction not to press, Lordship. They
Huh?
have already settled the issue.
Item 16.
16.
Mr. S.K. Sharma, learned counsel for the petitioner submits that the dispute has already been dispute has amicably settled between the petitioner and respondent. Accordingly, matter may be closed. In view of the aforesaid, the revision, this criminal petition stands closed. Yes, Mr. Chaudhary.
My lord, on 31/12/2017, my lord,
Ah.
I obtained a death certificate by the notary. She was dead, my lord. Petitioner.
Whose item?
Item 17, my lord. 18.
I submitted.
Court number.
Mr. N.N.B. Chaudhary, learned counsel for the petitioner submits that the petitioner has in the meantime expired on
31/12/2017.
31/12/2017. Has died, and accordingly the son of the petitioner, namely daughter of the is that is Jitumoni De Boidya, daughter of the deceased petitioner, namely Jitumoni Boidya, has returned. Jitumoni Boidya has furnished an authorized death certificate of the petitioner. Full stop. Mr. Borthakur has not submitted that there is no doubt. He has not raised any doubt as regards the death certificate. In view of therefore, this court also perused the death certificate. The death certificate is issued by the Register of Birth and Death, Municipal Board, Jorhat, with sign and seal and signature. Accordingly, such death certificate is accepted, and matter stands closed, being abated on the death of the petitioner. The communication of the daughter of the deceased petitioner as well as the death certificate is kept on record. It's safe, nothing is there on your part. Keep this.
May it please the Lord.
Yes.
One matter, my lord, NI Act matter,
Ah.
2019 matter.
Ah.
Fighting this matter with the my lord, having no other.
We'll take up 19 matter immediately on reopening January. Or you can renew this prayer next week. Not next week, week commencing from the last week before vacation. No, we understand your anxiety, but we are trying to streamline the things so that now we are around 2016-17. So far relating to revision petitions are there. Still 11-12 matters are there. So just we'll try to streamline next week. Then please repeat your prayer last week before vacation.
May please, Your Lordship.
Yes.
Lordship, I have to item number 4.
Hmm.
Lordship, this matter was engaged by from Gulaghar Saman, but from last few months that we have not contact with that person.
Okay.
So, Lordship, I have sent on notice also, but it was out for delivery. Lordship, I may pray for some time, Lordship, until this
What is the issue here? Conviction.
conviction 1 year rigorous investment. It's
You are
2000
Mr.
Yes, Lordship.
You are Mr.
I am on behalf of P.S. Hazarika.
It is submitted by the learned counsel appearing for the petitioner that they are having no contact with the petitioner and they had already sent a communication to the petitioner, and as per track report, that no notice has already been out for delivery
Delivery.
as on today.
Yes.
Accordingly, a prayer for adjournment is made for proper instruction. Prayer stands allowed, list this matter in the first week of January on a date to be, second week of January on a date to be fixed by registry.
Please, Lordship.
Item number,
Seven.
yes. List this matter before any other bench without me.
The Lordship, I beg to mention item number 10.
Yes.
Sir, the matter was, petition was filed for quashing of FIR.
Huh.
My lord, the charge sheet has already been filed.
Huh.
For JMFC South Shalmara, therefore I want for this matter.
Okay. The learned counsel for the petitioner submits that the so an FIR registered as so-and-so Sailva is under challenge in the present writ petition. However, investigation has in the meantime been completed, charge sheet has been filed, and the trial matter is at the stage of evidence. Accordingly, he had instructed the learned counsel for the petitioner has instruction not to press and withdraw the present petition. In view of the aforesaid, present writ petition stands closed on withdrawal. Interim order, if any, stands vacated.
May I please, Your Lordship. So the adjournment is not allowed, Lordship. I beg to mention for item number 13, Lordship.
Hmm.
And conducting counsel NBP Singha informed me over telephone that he is
January.
Lordship, I would like to mention for listing of a criminal petition.
Which year? 2000?
Well,
When?
next.
Yes, Bhatakar, what is this file listed?
May I please the Lordship? But your Lordship, earlier out of same FIR,
Hmm.
this honorable court was Assam order, my lord. Therefore came before.
You are inside.
No, my lord, outside. One AB is pending, my lord. Fixed on 12/2020.
CD when?
12/12/24 fixed as.
The CD on 12/12. Along with?
Byte AB number
Along with?
AB number 2734
2734
2024.
24. Yes.
My lord, this is a domestic dispute and amicably settled.
Hmm.
That effect, my lord, affidavit is shown.
Informant was, this was earlier rejected.
They are not rejected, my lord. Out of 4 accused persons,
Ah.
your lordship granted bail to the 3 persons,
Okay.
and 1 is remaining. Subsequently, my lord, this matter is amicably settled because of
The offense is under section 326B. It cannot
Hmm.
be said that it is amicably
No,
settled.
therefore, who is the victim?
victim is the informant, my lord.
Hmm?
The informant is my
Is the
brother.
victim? She was poured into a hot water, something
Yes,
like that.
Yes, my lord.
Is that it? Huh?
The allegation is like that.
And there were materials in the
Yes,
case that is so
yes.
far relating to the medical evidence.
Yes.
Have you made her a party here?
No, my lord.
No, then how do you know that she is amicable? How can we believe this?
The original affidavit is there. With
CD,
my lord, I will make a part in this.
learned, full case product call product case there is so and so, so and so. Okay, we'll do one thing. We'll permit you to correct the cost title and then we'll ask you to list it. Okay. Learned counsel for the petitioner has filed the second bail application on the alleged background fact that the dispute has amicably settled between the petitioner and informant, and it is the new ground on which the present petition is filed. Mr. Borthakur, on the other hand, submits that the offences are serious. So therefore, in absence of the informant, such ground may not be accepted. This court is also of the view that in the backdrop of the ground taken for grant of bail, let the petitioner implead the informant as respondent in this bail application. Accordingly, he is permitted to provide a fresh cost title before the registry as per extant norms with an advance copy to the learned public prosecutor. Mr. Please, this matter.
And
10th. Then we'll see on that. But without 3D, we will not grant you bail. That is for sure. Because police will not arrest you. We know that not yet arrested, and we'll want to see medical report. Then we'll call for the case. Yes, next case.
May it please, Mr. Lord.
Yes.
Matter, my lord, initially trial court has convicted the petitioner, my lord, for 1 year with a fine of a default in 1 month. But in trial, it has been, sentence has been reduced to 3 months with a enlargement of fine, enhancement of fine of 1,000 rupees. And I got record, my lord, from the record, there is a order for suspension, my lord. Probably he was on bail at that time.
So finally, appellate court granted him only fine.
3 months, my lord.
3
instead of
months
1
and
year.
fine.
Instead of 1 year, 3 months punishment along with enhancement of fine of 1,000 rupees, my lord.
What is his status? He is a government employee.
Secretary of the particular society, my lord. From where that PDS Rices has already been says, my lord.
Now, what do you suggest as an amicus?
In this matter, my lord, I just try to go through the evidences, but that evidence part is not there.
Okay.
I got the judgment of the 2 courts, my lord.
Okay.
So I could not contradict what have they have stated directly, my lord, but
Okay.
what have been projected from the
Judgment only.
Judgment
That
only,
is
my-
difficult proposition. It is difficult.
that I could not go through. But
Registry to provide the copies of the evidence.
that is not there, my lord.
There is-
LCR record,
Ah.
I don't find that evidence part, my lord. Judgments are there.
LCR also knows nothing is there.
Once I have seen, my
Mr.
lord.
Borthakur, what is to be done? You call the LCR, it is a conviction, appeal of 2011, date of incident 2009, 2007.
In other way, my lord, there is no defense witness.
Mm.
Trial as well as appeal, my lord, defense, I did not deduce any evidence, my lord. And another aspect is, my lord, for 405, my lord,
Do you think any perversity as in the judgments?
really not, my lord.
Not.
And one thing
If
is there, my lord,
apparently not, then what?
because in
Ultimately, this is
depth of evidence, my lord, defense evidence.
decision AP revision.
Revision, my
Yeah.
lord. Scope is otherwise limited.
Otherwise limited.
If my lordship peruse 405 CRPC, my lord, there it is also a compoundable offense, my lord, with the permission of court, my
406.
406, my lord. Pass,
Borthakur, please suggest us. Keeping these methods will help
Yes.
nobody.
Yes, ma'am.
2 things. One is if we appeal, we'll have to pass a detailed judgment. For that, we need the evidence. And second part is nobody is representing. We do not know whether alive or dead. We have
Yes, my lord.
engaged in
Status is-
amicus story. We can say that amicus has argued that nothing is there. But considering the nature of offense and decision of the appellate court and reduction of the punishment,
already reducted. my
reduction is there. Probation may be granted.
lord. 405 court, it's a compoundable
2011
offense.
method. Let us spend some time in good cases. We can pass this and then we'll have to again call for the. Okay.
God bless.
This will get all New Year's, it will be uploaded, not now. Let us clear this and concentrate on good cases. Yes, dispose of.
Obligement.
That's last line, registry, to communicate this order, to the learned trial court below so that the petitioner can be intimated as regards passing of this order through the learned trial court in as much as no lawyer has represented the petitioner, and it will not be possible on the part of the amicus to do the aforesaid exercise. Okay. Otherwise, we'll give him a relief. Thereafter, he will not be aware. We'll prescribe a time. Yes, next.
Lord, this matter, my lord, there was another review petition.
Which?
petition 6, my lord.
Yes, it is submitted by Mr. Das, M.K. Das, that another review petition connected with the present review,
168/2024.
i.e. review petition number
168/2024.
168
8/2024.
2024 is also required to be taken up together. Full stop. The learned counsel for the respondent has also submits that to that application, that review petition is required to be tagged with the present review. Accordingly, registry is directed to list this matter in the first week of January, along with review petition number
168/2024.
168/2024.
My lord, there was another writ petition which was tagged, but it has not come up today, my lord.
Review petition so and so, and along with
WPC number 7920/2018.
WPC 7920/2018.
2018. Deeply obliged.
Obliged. None appears for the petitioner on call. The present application is filed under section 397/401, read with section 482 of the Code of Criminal Procedure 1973, assailing judgment and order dated 7/6/2011 passed by learned Chief Judicial Magistrate, North Lakhimpur, Miss case number 162/2009, 162/2009, preferred by the respondent number 2. Preferred by respondent number 2 under section 125 CRPC. Application is filed.
Respondent number
Na প্রথম পড়া। Single CGM granting a sum of rupees 600 and rupees 900 per month towards maintenance of the respondent number 2 and her child. The further challenge is an judgment and order dated 22/11/2011 passed by the learned additional session judge FTC Lakhimpur, North Lakhimpur in criminal revision number 13/3/2011, whereby the judgment dated 7/6/2011 passed by the additional Chief Judicial Magistrate was upheld. Full stop. As none appears for the petitioner on call, we have requested Mr. N. Mahajan, learned counsel, to assists this court as amicus. Full stop. As assists this court for amicus. Mr. Mahajan has gone through the impugned judgment as well as the petition and assisted this court. From the materials,
My lord, item number 8, my lord. Three or something.
uh, the fundamental ground raised in the written statement of the respondent of the petitioner was that the first party, that is wife, had got sufficient income as she was working as Anganwadi worker, and the petitioner is rather was living below poverty line without any fixed income, and therefore the learned courts below could not have passed the impugned judgment. Mr. Mahajan, after Mr. Mahajan further submits, Mr. Mahajan submits that the only stand taken is sufficient means, having sufficient means by the respondent wife. Full stop. Referring to the judgment, Mr. Mahajan submits that both the learned courts below, after appreciation of evidence of PW1, that is the wife, and PW2 argues that the duly considered the evidence of PW1 and PW2 and had also concluded that the evidence of such PWs were not even challenged by the defense. According to Mr. Mahajan, through the DW1, the petitioner tried to make out a case, DW1, DW2, and DW3 tried to make out a case that the wife used to go to her house and not to return, and she wanted the husband to stay in her house, not stayed in her house. However, such facts were discarded by the learned courts below on the ground that there was no pleading to such effect, and thus in the written statement. It is also argued by Mr. Mahajan that the defense witness, that is DW2, even ignored, even stated before not knowing anything as regards the allegation made by the husband. According to Mr. Mahajan, after elaborate and meticulous discussion of the evidences, the learned trial court has arrived at a conclusion which is under challenge, and the learned appellate court, learned revisional court had also reappreciated its evidence and concluded that there is no illegality to interfere with the judgment of the learned appellate court. In the aforesaid backdrop, Mr. Mahajan submits that this court, Mr. Mahajan fairly submits that this court will have a little scope in the aforesaid backdrop to interfere with the decision in exercise of its revisional power. Full stop. This court has perused the materials available on record, also considered the submissions advanced by the learned counsel for the parties. After appreciation of the evidence, both the trial courts below has concurrently held that the respondent wife and the child was no sufficient means to maintain themselves, and the husband has refused to maintain themselves. Full stop. The argument of being an Anganwadi worker and getting salary will not ipso facto will not ipso facto lead to a conclusion that such salary or remuneration paid to an Anganwadi worker is sufficient to maintain the wife, herself, and the children. Therefore, full stop. Law is by the object of revisional power of this court is to set right a patent defect or an error of jurisdiction or of law. Such power can be exercised. Where the decision under challenge are grossly erroneous, there is no evidence or material evidence is ignored, or judicial discretion is exercised arbitrarily or perversely. It is equally well settled that a revisional jurisdiction of High Court should not be exercised in a routine manner, more particularly when the decisions, more particularly against concurrent findings of facts. The Honorable Apex Court in Chandra Babu versus State reported in 2015 8 SCC 774 held that normally revisional jurisdiction should not be exercised in a question of law, however, when factual appreciation is involved, then it must find place in a class of classes resulting in a perverse finding. Full stop. It is also equally well settled that the revisional power is required to be exercised so that justice is done and there is no abuse of power of the court. In the case in hand and in the backdrop of the evidence laid by the parties and conclusion arrived at, this court cannot hold that the judgments impugned are based on either no evidence or that certain evidence which either or no evidence or material on the basis of material or that material evidence has been discarded or irrelevant evidence has been relied upon. In short, the decision arrived at by the learned courts below cannot be said to be a perverse decision. Inasmuch as the fact that petitioner, that the wife is married to the respondent, married to the petitioner, and the child was minor at that relevant point of time and could not be maintained, and they could not maintain themselves, and that the petitioner husband / father did not maintain them, was duly established by the petitioner. That being the position, this court finds no merit in the present petition. Accordingly, same stance dismissed. While parting with the record, it is made clear that since the matter is pending since 2011, the parties shall be at liberty to approach the learned trial court under section 127 CRPC if there is any change of circumstances. While parting with the record, this court places on record its appreciation of assistance rendered by Mr. N. Mahajan. Yes.
In respect to item number 8, Major, earlier in pursuance to of your lordship's order dated 29/4/24, Major, I have received a report, my lord.
Oh, this matter. You have received a report, no?
After your lordship passed their order on 29/4, my lord,
Hmm.
immediately on the next day, the
Your problem is over. Now they have also taken, we'll close it. Will
and
not
he has been acquitted also, my lord, brought the case.
acquitted.
Immediately next day he appeared, my lord,
Ah.
and the case proceeded. My lord.
Okay. Pursuant to discourse earlier order dated. We initially thought to lay something, some guideline, and all, but now we'll not exercise that. We'll close it. Pursuant to discourse earlier orders, Mr. Bothakur has submitted a report as regards service of notice, etc. From that, it is seen that certain steps are being taken by state for mm, timely appearance of official witnesses. Be that as it may, in view of the enactment of BNSS, which covers this kind of situation of non-appearance of witnesses, and for the reason that the grievance of the petitioner has already been redressed and the petitioner has also been acquitted by the learned trial court by its judgment dated
7/24.
15/7/2024 in GR number 1059/2014. Nothing survives to be adjudicated in this present petition. Accordingly, same stands closed.
Obliged, my lord. Highly obliged.
Adjourn for time being, madam.
Time being, Friday there is no time being. You know that this court Friday no time being. What happened to you? Please tell us. We'll help you. Where is Mr. Ali? Ali is busy doing motions.
Yes,
Huh?
sir. M Khan is coming here after some time, my lord.
Till then, let us see what is the complaint case. 498A. Okay. January. Yes, next case. On the prayer of the learned council, the month of January on a date to be fixed by registry. Yes, item.
That's to the, my lord, NI case.
Can we have this status, Samujal? Can we have the status of this case? Is there any stay? CR case from the lower courts thing? Any stay order? Order sheets are larger than the petition and all. Their case is stayed. No, there is a stay. Pathakur, what is the provision 138? If the, suppose complaint is filed, before evidence the complainant dies, will the entire CA complaint case go? Legal heir is to be substituted. Here legal heir is substituted. Then an petition is filed, it should be dismissed. That was closed. Then what is the next? Yes, Mr. Day. Mr. Day. Both of they. Yes, you also. It's enlighten us.
Perhaps his case.
Huh?
It's my case, Lord, 12.
It's your case.
In fact, my lord,
What is the law says?
law says, my lord, he can be substituted, my lord, at any point of time.
Please show us that we are allowing dismissing this.
My lord,
Oh,
In
you
fact,
are,
Lord-
I thought I'd take assistance from you. And this is your case. You are sitting there.
and I was missing when I was thinking it was items 9, my lord.
Any wrong display?
No,
Huh?
at the time when I was coming, my lord.
There is a huge gap between 9 and 12.
So on the way, my lord, probably. So there are number of decisions I'll just I'll place.
Just they give a app decision. We are saying that law is
Initial-
settled. We'll dismiss it in
Lord.
3 minutes.
I'll just get. Yeah, exactly. That's a good. Yes.
One is enough.
Well, way back in Milord 1998, Milord,
Ah.
where Milord, your lordship kindly takes that Associated Cement versus Keshavanand. This was a case, Milord, where it was filed by a company. Your lordship kindly comes to the last paragraph, that is at paragraph 22. That is a 1998 Criminal Journal 856 or 80.
This was a
This is a
130.
company basically.
130.
130%.
It was 130.
Yes, yes.
Hard. None appears for the petitioner on call. Hard. Mr. Day, learned counsel for the complainant respondent. Isn't it? Okay. The present petition is filed assailing an order dated, isn't it 31/10/2017? The present application is filed under section 482 of the Code of Criminal Procedure 1973 for quashment of CR case number 2467/2008
Just to
pending in the Court of Learned Judicial Magistrate First Class within Kamrup Metro under section 138 of the Negotiable Instrument Act 1881. The further 1881. The brief fact is that the respondent number 2 filed the predecessor interest of respondent number 2 filed the connected CR case under section 138 negotiable 138 of the Negotiable Instrument Act. Prior to filing filing evidence on affidavit in chief, the complainant expired. Full stop. Subsequently, on an application filed by the present petitioner, namely present respondent number 2, namely Kamala Devi, the wife of the deceased complainant, she was allowed to prosecute, she was allowed to proceed with the complaint case as well as prosecute the same by an order dated, where is that order?
last
By an order dated
page 33, Milord.
Uh,
31/10/2017.
20.
31/10/17.
No, that was subsequent. Earlier it was allowed.
The substitution were allowed on 2/9/2010, Milord.
Was allowed on 2/9/2010.
10.
2010. Subsequently, the said Kamala Devi filed her evidence in affidavit as PW1 on 5/12/2012. An objection was raised by the accused that after the date of the original complainant, that is the husband of the substituted complainant, the learned, the accused is liable for discharge. However, such contention was rejected by the learned judicial magistrate, the learned trial court by its order dated 31/10/2017. Am I correct?
Yes, sir.
31/10/2017. And accordingly, the present application is filed. Full stop. None appears for the petitioner to represent. Full stop. The Honorable Apex Court in Ashwini Nanu Bhai Vyas. Citation. Ashwini Nanu Bhai Vyas.
1967 Criminal Law Journal
Ashwini
943.
Nanu Bhai Vyas versus State of Maharashtra, reported in AIR 1967 SC 983
943. 943.
943
Page 34, it has been referred, my lord.
943 held that the courts are authorized to conduct the prosecution by any person, and that word any person would include the son, any person would include the legal heirs of the complainant. In view of the aforesaid, and in terms of section 302 within bracket section 495, isn't it?
Yes,
CRPC.
yes, ma'am.
In view of the mandate of section 495 CRPC, this court is of the opinion that the complainant, that the respondent number 2 being the wife of the complainant stands on the footing of any person as advises under section 302 within bracket 1 CRPC. Full stop. In view of the aforesaid, this court finds no illegality or infirmity in order dated 30/31/10/2017, and the accused, in the considered opinion of this court, was not rightly discharged from the commission of offense only on the ground that the complainant has in the meantime expired before filing of evidence and affidavit. Accordingly, this revision petitions lacks merit. Same sense dismissed. Parties same sense dismissed. Any else here? Come on.
The lordship may direct us to appear before the
To whom? To you. You appear. He is not here. Then I would have directed him to appear.
okay, my lord, that can be done.
Because in his absence, we cannot pass to appear. Then it will be another revision petition will come. I has not heard, NBW is issued. Don't let us not complicate things.
Lordship, I'll leave it to lordship.
Special 12, no? For some time. Let us see. Call the next case.
I please your lordship.
Yes.
Last occasion, your lordship directed to provide hard copy of the evidence, man.
Uh, you are confident of 406
406.
or 417?
Earlier 406,
Then
then 379.
406 has rightly said no entrustment. Now it has come 379. When the incident happened, 22/12,
2007,
2007, and when the affair was lost?
7/12/2007.
Hard. Yes, whatever.
Otherwise, my lord,
Doubt is there.
doubt is there.
Doubt
my
is
lord.
there, but
Otherwise, my lord,
doubt.
key of
See,
the-
problem is this. PW2,
Yes, my lord.
if we go and take everything to be correct, the time when it was stolen, he with the wife of the informant and the child were eating.
On that ground, yes.
And there is nothing to suggest that the bike was left alone with him for a moment. Bike was there with the owner. He was in pharmacy. He said, I am hungry. So he sent his wife and child with him with the bike. They went to the shop. After coming into the shop, they could not open the lock. So there is nothing that the bike was left alone for some time with him. Nothing is there.
On that ground, my lord, police has earlier submitted final report, my lord.
Hard.
Otherwise, my lord, he is the person, my lord.
He is the person.
Yes,
See,
my lord.
problem is difficulty is there.
Key was with him, my lord.
He was
Of
with
the
him.
toolbox, my lord.
But there is a doubt
in
sometimes
the
because the
cross also, my
key could not be opened not by him,
Yes,
but
my
by others also. Ultimately, it was to be broken.
Yes.
So you never know. Key was with him. But nobody could open, not only him. We can doubt him that, okay, he said, I could not. But the third teacher tried, he
teacher
could not.
tried.
Ultimately, it was to be broken.
And my lord,
So when there is a doubt,
yes, my lord, in cross also, my lord, PW1 stated that I filed the case because I doubted.
doubt
my lord,
only on the suspicion it was filed. Suffered. Are you teacher now? You're provincialized. Service is provincialized. You don't know. He was a venture school teacher at that point of time. Might be he has got the benefit or might not have gotten. Hard.
My lord, knowing fully well, my lord, earlier the accused used to steal things from
Things
our
from
house.
us.
So knowing fully
Knowing
well,
fully well again he has
again,
serious doubt is there. Hard. Mr. Swenso, Learned Counsel for that. The present application under section 401/397/397 of the Code of Criminal Procedure 1973, read with section 482, is filed assailing judgment and order of conviction dated 6/4/2011 passed by learned additional chief judicial magistrate Morigaon in case number SCR.44/209 under section 406/417 IPC and convicted the accused petitioner to undergo what was the earlier first to Morigaon convicting the accused petitioner under section 406 IPC and sentencing him to undergo RI for 1 year and to pay a fine of ₹5,000. The further challenge is impugned judgment and order dated 18/11/2011 passed by the learned session judge Morigaon in criminal appeal number 11/2011, whereby the judgment and order of conviction dated 6/4/2011 was modified, the accused was discharged from the charges under section 406 IPC. However, he was convicted under section 379 IPC and was sentenced to undergo rigorous imprisonment for 1 year and also to pay a fine of ₹5,000. Isn't it? The learned counsel for the petitioner fundamentally argues that both the decision of the learned courts are ex facie illegal and perverse inasmuch as there is no iota of evidence to convict the accused either under section 406 IPC or under 379 IPC. In IPC, and therefore this is a fit case where this court should exercise, may exercise its revisional power to correct such patent defect and to avoid miscarriage of justice. Per contra, Mr. Bhattakur, learned additional public prosecutor, submits that the prosecution has reasonably been able to prove a case, reasonably been able to prove on the basis of circumstantial evidence that the petitioner has committed an offense under section 379 IPC, and therefore such findings of fact may not be reversed by this court in exercise of its revisional jurisdiction. This court has given excess considerations to the arguments advanced by the learned counsel for the parties. Also, perused the materials available on record, including the testimonies of the witnesses in the backdrop of the argument that the decision is a perverse decision. The prosecution story in nutshell, and as discernible from the FIR, is that an FIR was lodged by one
Dimbeshwar Medhi.
Dimbeshwar Medhi, alleging that FIR was lodged by one Dimbeshwar Medhi on 7/12/2007 before the officer in charge of Jagi Road Police Station, alleging that on 2/12/2007 at 12 noon, the accused petitioner misappropriated his money amounting to rupees 60,000 from the toolbox of his motorcycle. Accordingly, Jagi Road PS case number 196/2007, corresponding to GR case number 1266/2007 under section 379 IPC was registered. Investigation was initiated however, a closer report was submitted by the investigating officer on 30/10/2018, being registered as FR number 70/208 under section 173 CRPC for want of any evidence against the accused. On receipt of such final report, the learned Chief Judicial Magistrate, Morigaon, issued notice to the informant, and subsequently the informant filed an objection petition on 25/5/2009 in the form of a complaint, which was treated as a complaint by the learned trial magistrate, and was registered as SCR.44/2009 under section 406/417 IPC. The informant, opposite party number 2, was examined under section 200 CRPC, and thereafter the learned magistrate took cognizance of offense under section 406/417 IPC, and process was issued against the accused petitioner. During the course of trial, the complainant examine himself as PW1 and his wife as PW2. Also, the accused petitioner was examined. Statement of the accused petitioner was recorded under section 313 CRPC. Under section 313 CRPC. However, the accused did not adduce any evidence in support of his defense. After conclusion of the trial, the learned trial court convicted the accused petitioner under section 1406 IPC and discharged the accused for the offense under section 417 and was sentenced him to undergo RI for 1 year and to pay a fine of rupees 5,000 and by judgment and order dated 6/4/2011, which is one of the challenge in this present petition. Being aggrieved, the petitioner preferred an appeal before the learned court of session Morigaon, which was registered as criminal appeal number 11/2011 and was tried by learned additional district judges. Who tried your trial? And the said appeal was also dismissed by the learned session judge Morigaon by the impugned judgment and order dated 18/11/2011. However, the conviction of the petitioner under section 406 was reversed and he was convicted under section 379 IPC. However, sentence remained the same. Sentence remained the same. From the deposition, before dealing further, let this court record the deposition of the two witnesses. Can you give the soft copies, the type copy?
Soft copy I can provide.
Provide a soft copy. I'll correct a little bit. I'll follow. From the FIR, the evidence of PW1 and PW2, if are accepted to be correct, what is discernible from the aforesaid testimonies of the witnesses, including the cross-examination, is that on 2/12/2007, the informant PW1, his wife PW2, and their child were along with the petitioner went to Jagi Road. The PW1 and the petitioner went in the newly purchased bike of the informant, as the informant did not know how to ride a bike, and it is the petitioner who did know to ride a bike, and they are friends since long. The informant went to a bank, kept the informant and the accused. Informant PW1 and accused went to a bank. The PW1 withdrew an amount of rupees 75,000 from the bank. He kept 15,000 rupees in his back pocket, and rest of the 60,000 rupees were kept in the toolbox of the bike. The key of the bike was with the accused. Thereafter, the PW2 wife and the child joined them at Jagi Road, and the PW2 went to a doctor. Also, thereafter, all of them went to purchase some medicines in a pharmacy. At that time, the accused accused expressed that he is hungry, and accordingly, the accused PW2 and child was sent by PW1 to have their lunch, to have their food, and they went in the bike. And PW remained in the pharmacy while pharmacy, full stop. From the evidence of PW2, what is discernible is that PW2, the accused and the child went to a restaurant to have their lunch. They entered the restaurant, kept the bike outside locked, and thereafter, when they came back, then they could then the money was then the key of the toolbox could not be opened, and according to the PW2 could not be opened. Subsequently, could not be opened. Subsequently, another colleague of PW1 toolbox could not be opened. Subsequently, another colleague of the PW1 tried to, two colleagues tried to open the lock toolbox. They also could not open the same. And thereafter, they went to one Jayanto, one Jayanto Nath, went to the cycle store of one Jayanto Nath, who broke the lock of the toolbox. Then they found that documents of the bike was there. However, rupees 60,000 was missing. All this happened on 2nd of December 2007, and the FIR was lodged on 7th of December 2012. 2007. The PW1 deposed that he lost the FIR on suspicion. Full stop. The learned trial court, though convicted the petitioner under section 406 IPC on the conclusion that the money was entrusted to the accused as the bike was entrusted to him. However, the learned appellate court did not find any entrustment. Rather, according to the appellate court, it was the accused who had stolen the amount of rupees 60,000 kept in the bike, and accordingly convicted. Section 37, to convict a person under section 379 of the IPC requires 4 essentials. Firstly, that the accused had taken the movable property dishonestly, secondly, property was taken out of the possession of the complainant. Thirdly, property was taken out without consent of the complainant, and property was moved out. It is true that in the case of 379, there may not be any direct evidence to establish the aforesaid requirement. associate requirement, and there may be circumstantial evidences which will point the guilt to the accused only, to the guilt in the accused only. In the case in hand, from the evidence of PW1 and PW2 as recorded herein above, it is seen that when the bike was in possession of the accused, the either PW1 or PW2 were also present. As per the evidence of PW1, money was taken from the bank. He himself kept in the toolbox of the bike, and they were together till the accused left in the bike along with PW2 and their child. Therefore, there is no circumstance during this period even to remotely suggest that there is a scope of the accused to take away the money from the toolbox having the key in his hand. From the evidence of PW2, it is seen that they were together in the bike to the restaurant. They went together inside the restaurant, had their meal, and came back to the bike. Therefore, there is also no scope for the accused petitioner, as per the prosecution evidence, to take out the money from the toolbox of the bike. Even if toolbox of the bike. It is also the evidence of the prosecution that that bike could not be opened with the key which was in the hand of the accused person, and same was also tried by other two persons, though they were not any witness to the they were not brought to the witness box. The prosecution also adduced evidence to the effect that ultimately the toolbox key lock of the toolbox was broken by one in the shop of one cycle shop of one Jayanta Nath, and then also they could learn that money was missing. Therefore, from the aforesaid evidence, the prosecution has been failed to make to even remotely suggest that the money was taken out from the toolbox by the accused person, or that accused person even or any circumstance which shows that accused had the scope being with the bike, and there is no other person which could have taken out the money from the toolbox, inasmuch as it is the evidence of the PW2 that bike was kept under lock when all of them were inside the residence. In view of the aforesaid, in the considered opinion of this court, the prosecution has miserably failed to prove the guilt of the accused, not to say beyond any reasonable doubt. That being the position, this court is of the this court is of the view that the learned trial courts below has committed patent error as well as ignored the settled proposition of law. Then an accused is required to accuse that it is the burden of the prosecution to prove the guilt of the accused beyond reasonable doubt. Accordingly, the present revision petition stands allowed, set aside, discharged for want of evidence.
Last occasion I get it.
That is there. You give the soft copies, okay?
I'm obliged, man.
Yes, Bogwai, what is this?
Whether there is any life, because the complaint, petitioner is the complaint informant.
Ah.
And his complaint resulted in conviction of the respondent number 2
Ah.
by the trial court. Appellate court acquitted him. As against that, we have come in revision. But what we have come to know is that this complainant petitioner, he has expired in the year 2017 itself.
We'll close it
Until
at, we'll keeping an option open, that's all. That if anybody wants to, then they may agitate it if permissible under.
Yes.
Otherwise, this revision is not maintainable, Lordship, because he has filed a revision in his individual capacity, whereas the FIR was filed as president of an
Forget
organization.
about that.
He is not a victim as per the definition of victim.
We are not going to that. You raise if somebody comes here. Nobody will come at this stage. Let us give some time that the last case we have given. This is an absolute illegal conviction. Nothing is there. Yes, there might be something, but you cannot convict people like this. MSD Borgohai, learned counsel for the petitioner, submits that the petitioner has in the meantime expired and deceased and revision against acquittal. Revision against acquittal. She has also no instruction for substitution of the legal years of the substitution of the legal years. In view of the aforesaid, the present petition stands closed. However, if the legal years are still interested to pursue this matter, they may file application, if so advised, subject to maintainability of such application. Yes, what was this, Mr. Sarkar?
My lord, the my lord, Bongayo, my lord, convicted, my lord, the petitioner, my lord, under section 341 and punished for, my lord, simple imprisonment for 1 month. And my lord, under section 325, my lord, 1 year and fine of rupees 500. That was, my lord, modified by the lord and my lord, additional session judge Bongaigaon. Partly modified, my lord. He was acquitted, my lord. They were acquitted under section 341 and 1 year was, my lord, reduced to 6 months under section 325. And my lord, meanwhile, in the year 2020, one, my lord, died, my lord. And now,
What is your ground?
my ground is, my lord, basically, my lord, point is, my lord, no specific allegation against petitioner number 2, my lord. And my lord, there is an omnibus statement, my lord.
No specific. What is this offenses?
Offenses are, my lord, that the informant, my lord, as a PW1, my lord,
No specific statement against petitioner number 2 and
only 2, my lord.
other ground you told us?
Other ground is, my lord, omnibus statement
Okay.
that they have beaten, my lord. Only 1 lathi was, my lord, seized, my lord, that was not produced, my lord, subsequently. Not exhibited also.
Offenses under
Section 3, my lord, 325, my lord.
325/34?
No, my lord, 34 is not there, my lord.
34 is not there, then your individual overt act will be required. 34 also requires, but sometimes if you are present, you have acted in a manner may not hit.
No independent witness, other 2-3 point is there, my lord. The blunt object was not produced, no X-ray report, my lord. And the radiologist was not examined. And there is a vast, my lord, discrepancy of the timing. In the FIR, they mentioned the 3 timing, my lord. In the night 1:30, in the morning 10 AM, and in the evening 6 AM. Whereas in her deposition before the court as a PW1, only mentioned, my lord.
Okay, we'll come back. We will come back after 5 minutes, 5-7 minutes. We'll go through it. What are we just look into?
Yes.
And what are the other matters? 21 is adjourned or something like that? Okay. Yes.
That's my lord, the discrepancy in timing. There is also, my lord, one glaring mistake, my lord. My uh, 313, my lord, was not given any chance to bring out my defense, my lord. That question was not at all put, my lord.
Yes. Well, what is the doctor's evidence?
But,
Who is PW3?
PW5.
Huh? Who is PW2?
PW2, my lord.
2, 3 and 4 my lord co-villager. my lord.
W2, my lord, did not said, my lord, that he in that the beating by the accused. তই কাজিয়া ক'ব নোৱাৰো, হাল্লা শুনি মই দুপদীৰ ঘৰত মাৰপিট হৈ আছে, দেখা পাওঁ মাৰপিট হোৱা পিছত three, my lord. Paul Bermon, my lord. সন্ধিয়া 6:30 মান বজাত হয়, মই ঘটনাস্থলীত বাঁহৰ লাঠি দি মাৰিছে, মাৰত হুঁচৰি হাত ভাঙি মাৰ. This statement was not stated before the, my lord, police, my lord, under 16. That was, my lord, confirmed by the IO as well as in cross also, my lord. That was asked, my lord. Improvement, my lord. গোটৰে পদকীয় অনিতা মাহী হয় আৰু পদকীয় হাৰতি.
Who is PW4?
PW4 is also, my lord, the main statement was not, my lord, stated before the IO, my lord. দেখা পাওঁ যে মাটিত বাগৰি পৰি আছে আৰু পদকীয়গণ গোচৰীয়াৰ ঘৰৰ নিজ ঘৰলৈ দৌৰি গৈ থকা দেখা পাওঁ. This statement was not stated before the, my lord, IO.
What is that?
That, my lord, সন্ধিয়া 6 মান বজাত হাল্লা হয়, হাল্লা চিৎকাৰ শুনি মই ঘৰৰ পৰা ঘটনাস্থলীত আহো আৰু দেখা পাওঁ যে গোচৰীয়া মাটিত বাগৰি পৰি আছে আৰু পদকীয়দ্বয়ে গোচৰীয়াৰ ঘৰৰ নিজ ঘৰত দৌৰি গৈ থকা দেখা পাওঁ. Really said that who will beat, and this statement was not, my lord, stated before the, my lord, police. My lord, confirmed by the IO also. the PW5 is the my lord doctor.
What is 160, one,
PW6 is the my lord IO.
313 statement.
313.
P13 statement from record.
And I have the certificate. We don't move. But from the provision to cut.
The PW1 is put.
Otherwise, my lord,
No, otherwise, please, we'll go to that thing, CS, they made statement. We'll go to that, but how will it affect if the prosecution's witnesses testimony implicating this person is not even put to the use? What will be the implication? Keep it. Only one witness. PW1. প্ৰশ্ন 2 PW2 সাক্ষ্য দিছে যে আপুনি অন্য পদকীয়াৰ লগত মিল so casual. It is a recent judgment.
Para 19 is there, my lord.
That some judgment from by my Lord Justice Supreme Court judgment, is not it?
Yes, ma'am.
Hmm.
Sir, Honorable Justice, my lord, Rohington, Foley,
Sorry.
Nariman, and Navin Sinha, my lord.
Point C.
There, my lord, at para 19, my lord, section, may I read, my lord?
Yes.
Section 113 CRPC cannot be seen simply as a part of audio alteram partem. It confers a valuable right upon an accused to establish his innocence and can well be considered beyond a statutory right as a constitutional right to a fair trial under Article 21 of the Constitution, even if it is not to be considered as a piece of substantive evidence, not being on oath under section 313 CRPC. The
Some
importance of
substance is he must know that this is the implications against me, so that he can explain. It may not be evidence, but he is having a right to say that yes, no. Suppose it is circumstantial evidence. So and so says that you have last seen together, and thereafter dead body was found. What do you say? He may say no. After last seen together, I went to so and so, so and so. Then thereafter he might give an explanation. See, I'm giving an example.
there's a cross case is also there. There is a scaffold, my lord. That part I cannot bring, my lord.
He did not bring that. But there is another aspect. This is 313. Another aspect will be the you can be convicted, maybe, suppose, I'm saying suppose you can be convicted on the basis of a single witness, PW1, corroborated by the medical evidence. Now, in that case, whether not putting statement of the other accused will vitiate your right. That will be another aspect. Suppose what is necessary to convict you is put on you, and that has been done. Admittedly, there was a fracture. There are some discrepancies regarding time, regarding that you were present has been established by one of the eyewitness. But that statement is also not put in. There are some will apply, it might not, will not decide it. Look into this. Suppose we assume that PW1 evidence is there. That so and so came into my house, beaten me up. There is no expression or testimony of overt act by any of these accusers. 34 is not there. 149 is not there. Anyway, let us assume this is one part. Their presence at the place at that time is, say, established by PW2. So two things, it is one is that her testimony remains that I have been beaten up. Second part is that independent witness may not have seen that, but at that point of time, there was a kazia and I have seen this accused person. At least their presence is established. Their involvement may not be, they may be bypassers. Their presence is established. So suppose, we are not saying, commenting on anything, just assume. Here, this is an important chain. Their presence is there. PW1 says, I was beaten up. That is there. Now, the doctor says she was immediately brought to us. This is the injury. But interestingly, whatever doctor has stated is not put to him. Whatever PW says not specifically stated against him. Even PW1 only on 2 lines. Now, in this totality, how far the deficiency in 313 will vitiate the entire things, and whether in exercise of our power under section 482, it will be treated as a patent defect or error of law, or this is, I think, this is the issue. Apparently, in a given case, at this stage, we may not go in depth into that evidence of PW1.
And there is glaring discrepancy in respect of evidence of PW1, my lord.
What is the discrepancy?
FIR, my lord, he has to prove the FIR, my lord. Contradiction in FIR and her.
Did you brought in that in the FIR you have said that, but in the, did you brought in that? You have not. You have not. So how far at this stage we will go to in that details? That is also. See, PW2 in fact has not stated this. What is put in his mouth that PW said so and so. PW2 has not said that. PW2 has said, he says that PW2 said that you have beaten her up. PW said that I've seen some halla gulla and I came back and I saw them in that place. Where did he say this? Is it the way to deal with a person's liberty? Maybe he has done it. But the law is that you'll have to prove it. These are the procedures. Well, here's some other day. Two part. One is you have done it. Other part is that the technicalities of law. This needs some application of mind. Mr. Botakur, look into this. We'll first take up, this is a 2012. Mosumi? Possible this year? Not possible. January 1st.
My lord, it seems that accused was not provided, my lord, and not put all those questions, my lord.
So what will be the effect? That is what I want to know. This is one. And other will definitely hear him as regard improvements and all. Definitely, if it is improvement, such improvement that it creates a doubt on the trustworthiness or the even the whether it happened or not. I do not think that is there, because Elder also says that there was a quarrel and it happened in such and such place. Time is around such and such. He said so and so, this 3%. Now another aspect will come, whether overt act of individual will be required in absence of 34, 149 under 325. Because we will not go in depth with the analysis. Of course you'll go. We have acquitted two persons today because there is nothing. What happened to we'll have to. Cannot allow miscarriage of justice. We have acquitted 2% today, concurrent finding, but there is nothing. The judge has the belief that he might have done it, so convicting. That's all. Cannot be. Third, okay, opening case. Come prepared.
Was already heard by your lordship.
Ha. That make a matter. Fine only 700.
Fine, yes, fine.
Huh?
Here, my lord, court below is convicted under 447, 323, 324,
And what is the sentence?
Only appellate court 320, 447.
Sentence.
3 months, my lord. 3 months on each head, my lord. Appellate court, my lord. Under section 3.
Imprisonment not much, fine may be imposed.
Sentence only. Okay.
Fine.
Fine. Dispose of. Page of text. Yes,
Husband-
Mr.
Husband and wife, before your lordship, by
Mm.
way of criminal revision, my lord. Husband has been convicted for 2 years under section 379 and fine of rupees 1,000. Wife is been convicted for 6 months and the fine. Now, whole of the case is with regard to, my lord, theft of crude oil, my lord.
Oh, that case.
Yes. So all witnesses, my lord, nobody said that he is the person concerned who have moved the property of another without the consent of the owner. Nobody evidence. There is no evidence as such. Only evidence that comes into the this evidence on record is this, that he Radheshyam Gupta is the owner of the particular property. And before the occurrence and after the occurrence, some witnesses has seen it. That's all, nothing else.
Circumstances.
Yes. And so far with regard to evidence on record, it has come on evidence on record that he is not the owner of the property. The property is in the name of, my lord, the wife. That has come from the circle officer report that the owner is Sheila Devi. And during the investigation part, my lord, an agreement has been seized by the investigating officer, wherein Radheshyam Gupta entered into an agreement with one Bhaben Patwari who stands the trial with the other co-accused. So that has been evidence on record.
So there are two revisions,
Yes,
isn't it?
2 revisions, separate. What I am on, my lord, that here, with regard to the Probation of Offenders Act or 360 not been dealt with, one line only. It is not a fit case for this. That cannot be. That grounds has to be there. So in that view of the matter, this court can deal with this matter.
That we can definitely
My lord,
consider,
my lord.
but
I'm not-
evidence
that-
we will not go to the merits.
Yes, that can be done. He will be 73 years and
Yes,
she will be
yes.
65 years.
Considering 73 and 65, both husband and wife, huh?
Right.
That much.
There are judgments, may I give it, my lords? My lord's judgment is there. And of course, Supreme Court judgments are also there. Deeply
We'll
obliged.
summarize the principle.
Yeah.
We'll say that it has not been considered. Now, at this stage, in view of Supreme Court judgment, we have considered it.
Yeah.
And considering the period of offense, materials against them, their age, and they have suffered. So
Deeply obliged.
that much
Deeply
conviction
obliged.
remains.
Deeply obliged.
Tiwari,
My lord, yesterday evening only I was given this.
no problem. We'll give you time. CBI case.
What I have seen is that, my lord, in the judgment also it is reflected. Sir, advances were given to me, my lord. But in the long run, my lord, I paid, compromise was done with the bank, everything is there, my lord. But only because of the fact 120 was there, my lord. So the trial court did not compound the offense, rather under 120B, 1 year and 10,000 fine was imposed. Whereas in fact in the
You are the loanee, isn't it?
yes, I am the because my lord.
Appellant is the loanee. What about the bank officers? What special PP? What about your new special PPs? How can he do everything? Mr. Tiwari,
Same for them.
huh?
Same for them also.
Same
1
for
year.
them.
1 year,
No,
same.
there are two appeals, isn't it?
Yes, my lord.
You
Otherwise,
are the
I'm for
amicus is engaged in. In all the
Item
cases,
24.
amicus engaged.
Yes. in
All the cases. Okay. So bank officials and the beneficiary.
But two things are there.
Bank informant is there.
Informant is not there. That is why informant did not come because there is a compromise. They have taken the money. And that is reflected in the judgment itself. I'll show your lordship. That part is already there in the judgment that they have
Okay,
paid this
when
much.
can he come?
What matter is going on in Kottamatri?
This is our last method, isn't it? Okay, let us call 14. Mr. Tiwari, please wait for something. Yes.
Lordship, we have already returned the brief to the petitioner, Lordship. We are no longer the engaged.
Lordship, kindly produce the last order, Lordship.
Yes, death report.
Appellant expired, Lordship. This
Morigaon Police Station.
I have no report has come, Lordship. I have checked.
Mr. Sharma, pursuant to this court's order dated
It is against acquittal, Lordship.
this court, under its order dated 5/1/2022, on the submission of the learned counsel for the appellant, that appellant expired 4 years ago, requested call for a report from the officer in charge of Morigaon Police Station. Matter has not been listed thereafter. Matter has been listed thereafter only today. Full stop. In the aforesaid backdrop, Mr. Sharma, learned additional public prosecutor, submits that he may be granted some more time to complete his instructions. Accordingly, matter stands adjourned. On the next date fixed, Mr. Sharma shall obtain instruction from the which police station? From the
Yes, Jagi Road, Lordship. In his address, it is written.
from the officer in charge Morigaon Police Station.
In his address, that is PS Jagi Road has been written, Lordship.
Huh?
First title, it is Jagi Road written, Lordship.
Officer in charge Morigaon Police Station. Morigaon is no police station. Only Jagi, it will be Jagi Road. Morigaon is a district only, or there may be Morigaon Police Station.
I think it should be Jagi Road,
From
Lordship.
the superintendent of police, district Morigaon, through the concert police station, within bracket Morigaon Police Station and oblique or Jagi Road Police Station. Oh, give me. Jagi Road Police Station. Hello. Obtain instruction. Whether appellant Muhammad Sunamuddin, son of late Lokumuddin, village Nokhula Grant, police station Jagi Road. From the Jagi Road, no? From the, not SP, from the Jagi post, from officer in charge Jagi Road Police Station. PS Jagi Road, district Morigaon is alive. Who was the informant in Morigaon Police Station case? Is that it? He was the informant?
Yes, he was the informant.
Informant in GR case number 923/2007. Is that it? If you can give me the police station case, it will be better.
This is a complaint case, Lordship.
Okay, not
Complaint
necessary.
before the city.
Police station, so. Not in GR case. Then I think GR case means it may be some complaint, it was converted
Yeah,
into
in
complaint.
the-
Anyway, not necessary. huh?
Yes.
When? After Tuesday, next,
Later
next.
on, it was registered as Morigaon PS case number 197 of 2007.
Morigaon PS case number 197
Seven of 2007.
Informant in Morigaon's PS case number. I'll correct this order. Next Wednesday, Thursday, Tuesday, next Tuesday. Okay. Tuesday. Will not do anything. Don't come. You cannot struck off your names like that. You file an application, registry will do issue notice. A copy of the order be furnished to Mr. Bish. Yes.
Lordship, I was directed to take instruction at regard to the death of the
Hmm.
status of that. I have immediately on that day, Lordship, I have said. Was in queue, Lordship. Yesterday, I just inquired. That too, they are going to.
Who died?
Lal Burua.
Chandan Lal Borua. Okay.
That too,
So
Lordship.
that two will not come back. List is over. And what about on merit?
On merit, Lordship.
Virendra Kumar.
Lordship, one more difficulty. Paper book is required, Lordship.
Paper book required why?
Argue the case, Lordship.
Prepare it. You cannot say that. You go through it, we'll also go, we'll do it together. Amicus is there. There is no paper book, is not it? We'll see the evidence.
Copy has been supplied to him, Lordship.
Some copies were given to me, but the exhibits are not given. But at the end of the day, what I am on is, my lord, even my lord, it does not
That is what I'm saying.
objected. Page 10, your lordship, is the judge. 10,
Show him first. I have understood already.
I just got to know that there's a compromise, but that cannot be a ground for it. I mean to say.
No, not acquittal. So therefore you argue. You cannot
Yes,
also
yes,
say
judgment.
that I don't have a paper.
Therefore, Lordship.
No, that will not allow.
I will
You
not-
argue. We don't. We'll see what can be done.
There way which says that even if.
Oh,
compromise will-
forget about the judgments. Tell us on facts. Tell us on evidence. That you are not having
Copy has been
nothing.
supplied to them,
So
Lordship.
don't say that.
But my
Why
lord-
should you direct?
It's not a case where the CBI is the informant. It is the bank is the informant. But the IO says that I don't know who had filed the FIR. I have just been directed to investigate. I have investigated. Now the second part remains is that I placed 5 checks before the bank, saying that you advance me this. The bank says no. You don't have sufficient money in your account, and since you are already availing CC limit, now we'll give you as overdraft 30 lakhs. So because I'm already having a CC account, now they can enhance my. And that was communicated, the telegraph messages were there, journal officers given that. Those were seized also, but the IO did not produce those materials before the court. Now, second part
See,
is that. the
He's an
money-
amicus. You are a stand PP. He is also having the same material.
But
When?
they have been
This is a
supplied.
matter of 2014. When?
Trial
Supplied
is
with the
from
copy.
1991.
Huh?
He has been supplied with the copy. He's been supplied.
Definitely. Why should we supply copy to CBI and spend money?
Lordship, with the other PPs, Lordship, copies has been supplied.
Will not supply because
other
you are
people
the
also-
mighty CBI.
No.
You do arrange your thing, what you want to do. A person is accused is not being represented by lawyer, we are helping him. Why should we help you? Give him. We will not pass any order, giving copy. This will be a remain a trend. You apply certified copies. You apply certified
I will
copies.
take-
And we'll be merciless. I am saying it. Merit for will go by law, and this will not tell your CBI that we will not going to concede to all these prayers of 2014 matters.
My lord, one part, my lord. As an amicus, my lord, I'm placing one. The bank, my lord, may noticed because they have already compromised.
Forget about if there is a merit, forget about bank. We'll see. What is the allegation? How entrustment was there? Where? How misappropriated? Let us see it. Where is it?
420 and 120B.
Huh?
420 and 100. There is
420. What is the sitting?
no
What is the inducement? What is the sitting? Let us see. Or whether is a mere judgmental error resulting in financial loss.
And that loss is not there.
Maybe
Judgment itself
loss is there.
And my lord, the most important part is that the 3 officers of the bank, their
Mr.
account-
Tiwari, if you have something, help him. But
My
court
lord,
is
definitely,
not going to
definitely.
give him
I'll
anything.
definitely.
We are not passing any order, not today. We'll give you time. It's not that we'll not give CBI in all cases time to argue. But we are saying through you to the CBI that this will not allow that we don't have brief, we don't have file. This is a long pending. CBI cannot take that plea. CBI or the state cannot take that plea. I don't have record. Sorry. We can say when petitioner's counsel is not representing, we have engaged an amicus. Of course, we'll have to give him the copy. He cannot spend from pocket and get certified copy, but we'll not give that benefit to CBI. That is what I'm saying. Of course, we'll give you time to prepare to do all pending cases. We understand, but that period cannot be stressed into more than maximum. Sometimes we will not even given a date only. We will hear it. It will be perfect till Bihu, maybe after Bihu, January. So second week of January. Give a copy to him.
I'll
Don't Xerox on your, give it copy to him.
I'll do it by myself, Lordship.
Obliged,
I'll-
Lordship. Deeply obliged.
Sorry, Lordship, I couldn't.
Hmm?
Sorry, Lordship, I couldn't be present.
Yes, Mr. Sarma, what was this?
Lordship, this revision is against the judgment and order dated 25/2009 passed by the additional session judge Bongaigaon.
What is wrong?
Wrong is that the complainant didn't go to the police station. She directly went to the magistrate. And that too after a period, after 1 day, Lordship. The incident occurred on Saturday. Sunday she didn't go. Then on Monday she filed a complaint case, Lordship.
Then
Have gone to the police
so
station.
can that be a ground at this stage?
The police station is only 3 or 4
Can
kilometers.
that be a ground? You have been convicted. You have not challenged that criminal CR case that no, without going to the police,
Police
this
station.
could not have been allowed. That ground we are not taking at this date. What are the other?
Other grounds, there is a mismatch in the statements given by the Mrs. India Cross, Lordship. Some has stated there was no student, and one have stated that there were some students, around 20 students at the time of the incident, Lordship. There is a mismatch in the
You have been sentenced under, convicted under section
323 and 34, Lordship.
323. What was the, who you have beaten up the child?
My mother.
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 Child went to the school.
She went
collect-
to
collect
bring
to-
the
collect
free
Mother.
ration,
Free ration,
something
mother.
like that.
Thereafter headmaster denied. Thereafter mother.
He's the
came-
headmaster.
Headmaster and his son assaulted the mother of the minor child minor. All the witnesses are eyewitness minor.
I've seen them.
Oh, eyewitness minor. Or
Are you still working? Huh? Retired.
In the
Got
year
the pension?
2009, he was 55 years.
Are you having any relation with the, any link with the client?
Lordship, there is no
The
medical-
benefit what is required to
My
be
lord.
granted, you have already gotten it. You have retired, you are getting pension, now will be convicted.
no medical documents were
not necessary, my lord. Self built. It was assaulted
323
by
what-
built, my lord.
what-
Both the
What
son,
medical is required?
son and my lord, headmaster, my lord.
said that she have gone to the doctor, but no medical.
We are safe today.
My lord. Otherwise, it is not a fit case, my lord.
We are safe today. We are not coming back.
Only fine imposed here, my lord.
Only fine imposed.
You will have to give, my lord. Because more than the 500, my lord.
500 fine.
But he will have to more than that, my lord.
You have try to have a contact with your client and come back in the first week of January. Save off for the day being Friday. First week of, give a date. The 2001 of the oldest pending.
2009, my lord.
My idea was to close all this before 21st. But to appeal this conviction, we'll have to look into. Come prepared. If you can show apparent inherent contradiction, I have not seen.
Not any contradiction, man. All the eyewitness, all of them.
All eyewitness, all said he went there, says beaten above. Only 500. Why should you interfere in a revisional jurisdiction? That's all. Okay. 6th of January.